Mendocino County Employee Retirement Association Board to order. Judy, would you like to conduct the roll?
Yes. Ms. Shatmeyer is absent by prior arrangement. Ms. Forrester?
Here.
Ms. Cavanis, also absent. Mr. Parker?
Here.
Mr. Jurdy?
Here, present.
Ms. Smith, also absent. Mr. Cromer?
Present.
Mr. Shoemaker?
Here.
Ms. Harris?
Here.
And Mr. Anderson?
Here.
Thanks.
Okay, we're just noting that people can participate via the Zoom link or submit written comments per the state guidelines during the COVID event. And the next thing on our agenda is Pledge of Allegiance. Okay, I'll leave it in pledge.
Thank you.
I pledge allegiance to the flag of
the United States of America
and to the republic for which we stand, one nation, under God, indivisible, liberty and justice for all.
Excuse me, Tan, may I ask, anyone know how to ramp up the sound on an iPhone?
The buttons
on the upper,
the buttons on the upper left.
On the side.
Yeah, I know that one. Yeah, but there's like you do with a telephone, so you press a button and it goes to speaker. That's what I'm looking for. Anyone know how to make it on speaker?
Well, first touch the screen and then the speaker icon will appear.
Okay, and then just do it that way. I'm going to try that. If I disappear, I'll be right back.
Gary, if you go into phone and go to your keypad, the speaker will show up.
Oh, great. Thank you. Thank you so much.
You're welcome.
Thanks, guys. Okay, bye.
Okay, that takes us to public comments on non-agenda items. Members of the public are welcome to address the board on subjects not on the agenda. The board is prohibited from taking action on matters not on the agenda, but may briefly answer questions. Individuals wishing to address the board under public comments are welcome to, per the instruction above, and members of the public have 3 minutes per topic. Do we have any members of the public wishing to address us on non-agenda items?
Star 9 to raise your hand to ask questions.
Okay.
No comment at this time.
Okay, that takes us to a proclamation honoring Trustee Leland Parker for his service on the Mendocino County Employees Retirement Association. And Lee, if you don't mind, I'll read the proclamation. Whereas Lee Parker has served with distinction as a Board of Retirement Trustee since February 14th, 2017, subsequent to his appointment by the Mendocino County Board of Supervisors. Whereas Lee's exceptional knowledge and understanding of investments, extensive experience in serving on other boards, his welcome and respectful demeanor, and true appreciation for Mendocino County has been a valued addition to the board. And whereas Lee's perspective and thoughtful attention to policy development has helped the board make important investment decisions, retain the best consultants, and apply exemplary financial principles that will guide the board for years to come. Whereas Lee attended the University of California, Berkeley Haas School of Business, Fiduciary College early in his tenure, and his fiduciary obligation to MSERA and its members was at the forefront of every recommendation and decision he has made. Whereas Lee's dedicated service includes his leadership as vice chair, his thoughtful participation in both the strategic plan and board work plan, his expertise as a member of the audit committee, and his assistance in making difficult decisions regarding the historical benefit review project. Whereas Lee has repeatedly demonstrated his commitment and dedication to serving as trustee. He has always exhibited the highest principles of collegiality and respect for MSERA, its board and staff and members. Now, therefore, be it resolved that the Mendocino County Board of Retirement honors and applauds Leland Parker for his service and expresses its sincerest appreciation. Lee is wished continued success in all future endeavors. May he enjoy his new home and beautiful views in Bainbridge Island, but return to often visit us here in Mendocino County. So thank you, Lee.
Thank you. Thank you all very much. It's been my great pleasure and honor to serve on such a wonderful board with everyone is dedicated to the mission of serving our members. Doris, you've done a great job. Judy, you're where the rubber meets the road to the members, and you are the public face for the organization. And I really appreciate your charm and professionalism. Jeff, you're the lookout on our ship, making sure that we hold a steady course. Much appreciated. Dan, your leadership has been great as chair, and it's nice to know that we have such a close liaison with the Board of Supervisors. And the rest of you trustees, Robert, I want to thank you too for your stewarding our investments and keeping an eye on them on a day-to-day basis. It's one thing for us to pick managers, but you actually keep an eye on what they're doing for us. And couldn't go without thanking Callan and Associates for their advice that they give us. Their good advice, as shown by the managers that we've hired at their suggestion, and that we're always consistently in the upper quarter of pension plans throughout the state and our investment results. We've been very blessed in that regard. Also, our accountants and our actuaries have served us very well. So all, without exception, everyone that I've met and come to know through my few years of service with the pension has just been exemplary. And thank you so much for putting up with me. Oh, and as a final note, as the public member, everybody else, we're all fiduciaries to the members of the association. But as one of the two public members, it fell upon the public members to be able to report out to the general taxpayers as to, we're sort of minding the store for the taxpayers, you might say. And it's been my pleasure on many occasions to report out the confidence that I have and that they should have in the organization. So thank you again. And seriously, any one of you, all of you, come see us up here in Washington when you're up our way. Thank you.
Lee, we're really going to miss you.
Yeah, Lee, I gotta say, you were a super breath of fresh air when you joined the board. You've been so very constructive, in your background, investment background has been really valuable to us. You did a great job of filling a seat that I thought was only a negative seat on this board, and made it very positive.
Hear, hear. Very much agreed by your other public member.
Thank you so much, Lee, for your service here.
As a new member of this board since January 2019, Lee, you've been open and welcoming, I think, to Quincy and I both. You have a great sense of humor, and you definitely bring a different balance to the board and a perspective. So I thank you for that, and being opening and welcoming to us and bringing us in and helping guide us along the way. So you'll be missed.
Yeah, other than your sound investment advice and guidance always, I will certainly miss your one-liners. So you'll be here in spirit.
I echo that one.
And thanks for your kind words, Lee. I really appreciate that.
Well earned.
Thank you very much, Lee.
Bye.
Bye, Lee.
Bye.
We'll see you again.
Best.
We will see you again.
Okay, bye now.
Bye there.
Okay, that takes us to the consent calendar. We have the minutes of February 17th, 2021 board meeting. We have the February 2021 retirement report and the preliminary monthly financial report. Does anyone wish to pull or discuss any of the consent calendar items?
There was a correction in the minutes. It's been noted and taken care of. It had to do with the attendance.
Noted. Okay. Well, I'm not seeing any or hearing any concerns with the consent calendar, so we'll record that as approved. And then we're on to discussion regarding the historical benefit review project, status report, and project updates.
Thank you, Chair Judy. The project staff report on the correction project is provided in your packets. To date, 349 members still remain to be recalculated. 189 have been completed and received their notice. The summary totals are available on page 15 of the report. If you have any questions regarding that, I'm happy to entertain any questions you may have. Public comment in relationship to the project was provided as part of the board packets and is also available on the website.
Do we have any questions or comments for Doris?
I can say that we're making a little bit slower progress than what staff had and myself had initially hoped. So I'll be, updating the board with timelines as things become more clear and we see how things progress over the next few months.
Okay, thank you. Do we have any public comment on this item? We do have a letter.
I see no public comment at this time. Again, it's *9 to raise your hand to speak. I will say that we did have a successful webinar on Monday afternoon regarding the project with about 20 retirees in attendance.
Okay, well, thank you. So do you want to just add a little more flavor to that? Did the MSERA organize that, or was it organized by another group? Or?
It was organized by MSERA, and the information is published on our website. We will be doing another webinar on Thursday morning at 10 a.m.
We invited everybody who had received a notice that they were impacted by the project, although the webinar is actually open to anyone. And this was based on direction and comments at the last board meeting to create these. Due to the COVID restrictions, we are not able to have any in-public meetings right now, but we did schedule a couple of 2 sessions for Q&As with membership. And we can certainly add more if there happens to be demand. But we had our first one on Monday. Richard, did you have a comment?
Yeah, I did. So do you have them up to the whole session to be viewed by the public?
We've recorded the first one and we were going to wait until after the second one occurs and maybe merge it down into one session of Q&A so there wasn't perhaps duplication or to make things a little more clear. But as of right now, all of the materials are available on the website, just not the recording of the actual session from Monday. But we did record it with intention to post.
Okay.
Okay. Well, thank you, Doris, for doing that. So you said there's no public comment at this time on this item?
No public comment at this time.
Doris, did you modify the FAQs based on any input at that meeting? Is there any update for the board on that issue?
No, there was the one change that we had discussed that I'm working on adding to the FAQs. but that has not been produced yet.
Okay, well then that takes us to number 5 on the agenda, which is discussion and possible action regarding process for appeals regarding correction notices and historical benefit correction project.
Thank you, Chair Jurdy. In the board memo provided in your packet, it outlines the process for board appeals. As you may recall from our error correction and appeals policies, the first step is for a member to appeal to the executive director. Subsequent to that, a secondary appeal is made to the Board of Retirement. The memo included in your board packets lays out that process and the timeline in which those appeals would be moved to the board. If you have questions regarding the information within that memo, I'll answer any questions you have regarding the process.
Richard? Richard, we don't hear your audio.
I thought at the last meeting we talked about extending the 30 days to 60 days for people to appeal. This is my first question.
Yes, there is a 60-day window for the member to file the initial appeal with me. And then after that decision, should they wish to appeal to the board and they actually appeal and submit a statement of claim, within the retirement system then provides all of the information relating to the recalculation the member's claim to the member. They have 30 days from that point to submit an intent to continue with the appeal.
So
this is as laid out in the appeal and administrative hearing policy.
Okay, so when they appeal to you, they're given all their material. Is that correct?
We're updating that process that now when the initial appeal received by me, that they'll get a copy sheet of the correction materials at that time. It's not required by the policy until they actually file a statement of claim with the board. In the past, with the one appeal that we have worked through to the point where they're now appealing to the board, we provided a number of documents, but not the full calculation to explain the events that were causing this particular member's benefit to be recalculated and in support of that. So there is a full correction file, and we will be, I think, providing that to the member earlier upon the initial objection to the determination letter.
So if somebody calls and asks for their file and they have not appealed and they're going to make a decision to appeal, can they obtain everything in the file around the correction?
Well, yes, and here's my suggestion to members, because a lot of members have been requesting a copy of their complete retirement file. They're requesting it before we've ever had a chance to review or do any work on their particular correction. And we will provide a full copy of their file, but it doesn't really have any of the specific items related to the recalculation. It's a little soon to provide that. And then they just have to keep requesting updates to their file. And due to the volume, it's going to take us about 4 weeks in order to redact and prep the file and get it to people when they're requesting a full copy of their file. If they wait till they receive the correction notice, we have a specific file of just the original calculations, the recalculations, and all of the supporting document that went into the analysis on the review of that recalculation. And that recalculation file would be available upon the time they receive their correction notice.
Okay,
but
great.
There's been a large push for people to request a full copy of their file, which is often many, many hundreds of pages long, dealing with many things that are not relevant to the recalculation. We will produce those. It is going to take us probably about 4 weeks to turn those around due to volume and the fact that our extra help person got a full-time job, so we're shorter staffed than usual.
Okay, thank you for those answers. You did raise one other issue I had a question about. What type of a material is being redacted on these reports?
social security numbers, dates of birth, similar those items, because even though we're sending it to that member, because we're transferring those files either electronically or through the mail, we are taking steps to redact certain personally identifiable information like social security numbers that would be at issue if those records become lost. Additionally, for folks that may have a disability application and medical records within their file, we may be redacting portions of that, again, for concerns over privacy if the records were subsequently breached.
Great, thank you. I appreciate those answers. I have one more question. So down in item, right below item 4, I guess it's an item 4, it says no witnesses may be called to testify, but written evidence such as a declaration and official records are permitted. What I wondered is, how does somebody who's appealing this get testimony from somebody they believe is pertinent to the process? If they wanted somebody that was on staff at the time they were processed to answer questions, how do they get them in there if there is no witnesses allowed?
The guidelines in the board memo you received are actually taken directly from the administrative hearing policy. Now, if a member wanted to, let's say, have certain questions answered by payroll staff, MSARA staff, someone else who had knowledge of events, they would need to reach out to that person and get a written statement answering their questions that they would be asking. But based on the policy that's been in place for a period of time here at MSARA, the appeals to the board are limited to oral arguments without any witnesses, but written declarations are allowed.
Are they allowed representation?
A member could obtain representation at any point in time, certainly, and they are welcome to have their representative or attorney present at any hearing.
Okay, thank you very much.
Jim, did you have a question or comment? Your audio is not coming in.
Richard asked my question. Thank you.
Okay. Catherine, welcome. We're on item 5.
So I do have another question. It may even kind of bleed into the next item on the agenda. When this hearing occurs, will Jeff be there, and will our other attorney be there, or do those other attorneys only come into the process if the thing goes to court?
Jeff will be there as counsel to the board for any appeals to the board. Nossaman may assist with preparation of written arguments and may or may not be at the actual board hearing. Jeff, do you have a comment on that?
I think it's probably case by case. I mean, I suppose Doris could be presenting the case, or it would be Ashley Dunning from the Nossaman firm.
Thank you.
Okay, do we have any other questions or comments on item number 5?
Jim?
Yes, I did have one, and it goes back to the retracing back to the disabilities, where in some cases there's a substantial amount of medical information that's provided. Has there been any thought to, in those particular cases, allowing a member to come in and review a file as opposed to transmitting those documents to them, or do we have any choice?
If the member requests it, we're going to release it. We do have certain restrictions on the release of psychological evaluations, but other medical, if the member requests it, those reports are provided. Now, as far as whether a member could come in and review their file, we have no paper files for someone to come in and sit down and review. Everything is in our imaging system. And that's in part why it takes us a little bit to prepare records, because we have to download those records, go through and redact those records, print them, because many retirees would prefer a paper copy as opposed to an electronic format of the records, and then get those mailed out to our members, often who don't necessarily live close by to our offices. So there really isn't a good way for anybody to come by and look at their particular record.
Thank you.
Judy, do we have any public comments on this item?
We have no public comment at this time.
Any other board member questions or comments?
Kind of a summary comment. So what you're doing is making available to them the process file. And if they want more than that, they can ask for more than that.
As part of the appeal process, we will automatically be providing a copy of the correction file.
Right.
Members have been advised from other retirees that they should get a full copy of their file, and we're getting multiple requests for that, and that's what we're dealing with right now. That's going to take probably an average of 4 weeks to produce. And because they're requesting it before we ever get to their calculation, now we're getting multiple requests for updates that have been added to their file since we had originally produced the request and provided a copy of their file to them. And honestly, we haven't added anything to their file because, again, we haven't gotten to that person's calculation.
No, I just want to make sure that you're able to communicate to folks that these are two separate files, and your medical history or whatever retirement history in some sense is irrelevant to this process file.
People feel that it's important they have a full copy of their file. That's what they've been told by other retirees, and we're getting multiple requests for copies of their full retirement file, which again, it covers every address, beneficiary change, direct deposit change, every tax document that we've issued to them for their years in retirement. It does include their calculation information from their original retirement and service purchase loans. Those items also, though, would be included in the correction file. But for a couple of the files we produced, we're talking that it took probably a ream of paper that we had to then ship.
Yes. Well, if anybody asks me, I will suggest to them they just look at the process files.
Thank you.
Okay, seeing no other questions or comments on item number 5, we'll go to 6, which is discussion and possible action regarding proposed Nossaman contract amendment.
Thank you, Chair Jurdy. Nossaman currently serves as the board's fiduciary counsel. Additionally, they did provide some assistance with a review of materials for the historical benefit review project and review of records that were subject to disclosure for public records requests in relationship to the project. Because Jeff's service to the board is limited to advising the board on board matters and process, he is prohibited by his contract from providing any services in relationship to administrative hearings or litigation as far as representation of the association, because he's the board's attorney. So with that, in the event that we do move to litigation, we would need to have advocacy counsel, and we are recommending that we add Nossaman as services as advisory, as advocacy counsel in case of litigation. We're also requesting in the board item for today an increase in the budget, and per Nossaman's request, they would like to remove the administrative appeals and litigation out from under the budgetary cap. They're requesting a cap based on current usage and how much is left from the fiscal year of an additional $30,000 to provide support for non-litigation, non-hearing matters.
Okay. Jeff, do you have anything to add?
No, I think that was a good summary, and I think Doris and I both recommend Nossaman and the approval of the amendments to the agreement.
Okay. Do we have any questions or comments on the proposed motion?
You'll entertain a motion? Oh, okay.
The proposed motion is to approve the proposed contract amendment with Nossaman LLP to provide advocacy services and increase the fee cap to $130,000 per fiscal year.
So moved.
Catherine, we can't
second.
hear you.
I know. I'll second.
Okay. Do we have any board comment or public comment on this item?
I have a comment. I'm wrestling in my mind with some past history that we had in the past used an attorney that prepared initial responses for us to disability claims. And we eventually found, and then that attorney would work with us during the hearings. And I believe we found that to be a conflict of interest. And we went off into the journey of having outside hearings. But Jeff, I can't remember if you probably weren't. You probably came on after that occurred.
No,
Jim
actually,
Anderson,
I was here.
Were you?
I think I raised the issue.
Yeah. So is this similar in some way? I mean, they're the aren't they the folks that have told us we need to do all this stuff? And now at a hearing, they're going to come back in and tell us we need to do all this stuff again. Isn't that the same as what happened before?
So I can see, I think that's a good question that you're raising. And the thought occurred to me as well that they had advised the board to, in terms of the steps that it took when it filed the VCP. But the difference is now there is going to be a formal hearing process. And that's why you do need to have a counsel that will sit with your board and advocacy counsel. So it is akin to the current disability process where there's another attorney who's in the Sonoma County Counsel's office, my former office, who is the advocate when there's a hearing. When that decision comes to your board, then separate counsel, myself, sits with the board. So it is analogous to the disability process. I understand that the Nossaman firm was involved some time ago, but I think that that's a separate process. And now we're going through an appeal process where you have separate counsel. And so I can see how it might give the appearance of some taint, but I can tell you from a legal perspective, it is not a conflict. It would be if that same counsel was the advocate in the hearing and then came and then advised you in closed session. Because what's going to happen at an appeal hearing, as Doris's memo laid out, is that the member will put on their case and the Nossaman attorney will put on their case. You can ask any questions that you have of those two parties, and then you'll recess into closed session and I will be your counsel.
Okay, thank you. That clarifies it quite a bit.
Do we have any other board member questions or comments? Judy, do we have any public comments in this item?
No public comment at this time.
Okay, well, we have a motion. Can you conduct the roll?
Yes. Ms. Forrester?
Yes.
Mr. Jurdy?
Yes.
Ms. Smith?
Yes.
Mr. Cromer?
Aye.
Mr. Shoemaker?
Aye.
Ms. Harris?
Aye.
And Ms. Kapnis?
I abstain.
Thank you.
Okay, that takes us to item number 7, investment matters. We have the monthly investment report.
Hi, board. Yeah, before you, you've got the monthly investment report for the month of February. It was a decent month. The markets kind of continued their upward trend. That's been basically happening really strongly since November of last year. The equity markets maintained high valuations, while at the same time the bond yields have been rising as well. You can see that in our report where we're having to buy a little bit of fixed income at the end of the month. Luckily, we are maintaining our asset allocations pretty closely. The low end of the target band for domestic income, but we're about 2.5% over on our international equity allocation. We're about 1% overweight on our domestics. So overall, you can see that we've done pretty well so far this year. And, you know, we're positioned right now to hopefully maintain this. The economic outlook is pretty good for the country. I'm not too sure what is going to happen with the Fed meeting today, but we'll see what happens. We got a pretty liquid portfolio, so we will maintain the asset allocation bands regardless of what happens. One additional thing I would like to also let the board be aware of is we just found out that we are going to have a capital call for JP Morgan for our infrastructure fund April 1st. So that is coming up, and hopefully it's a good time, you know, well, now is a good time for us to get in because of our particular overweights. So that's going to be happening very shortly.
Any questions or comments for, go ahead.
Yeah, Robert, just for clarification and to remind me, on those two funds that we agreed to invest in with the infrastructure, it was an equal distribution to both, and we haven't heard from the other one yet, correct?
Not yet. Yeah, so it's going to be a little under 17 million that'll be moved in, about 2.5% of the current portfolio.
Okay.
Robert, does that capital call reflect the full amount of the commitment for the JP Morgan fund?
Yeah.
Thank you. I'm sorry, Jim?
Yeah, Robert, when the capital is called, would it be just for the weight of that particular manager, or would it be for the full weight of infrastructure with the balancing to occur later between the two managers?
No, it's just that it's literally half the amount. We committed to a specific dollar amount in December 2019. So that's the specific amount that they're calling, and that's what we're going to send them. It's basically half the entire infrastructure allocation. And frankly, I'm hoping that by the end of the year, we'll get the other call also. Should be good.
Okay, well, thank you, Robert. Do we have any public comment on this item?
We have no public comment on this item.
Okay, all right. Thank you for the update, Robert. Okay, that puts us over at item number 8, which is administrative report.
Thank you, Chair Jurdy. So the administrative report does reference the fact that at the last meeting, the board had requested some question and answer sessions be set up for membership regarding the project that is covered in the first part of the memo. We've done one of 2 sessions that we've had set up. The next one occurs on Thursday at 10 a.m. It is available and open to any member who wishes to attend. There is a link on our webpage. We do have a dedicated webpage for project information now, where all of the policies and resolutions and frequently asked questions and other documents are provided in one space for members. So the second item regarding office operations is, and I mentioned it earlier, our part-time extra help position is currently vacant. The person was able to secure full-time employment, so congratulations to him, but now we are short-staffed. We will be looking at filling that part-time position. I am looking for perhaps some board direction. I am going to be asking to include that in the budget that will be coming to you in April or May. Does it come in May? May. To leave that position in our budget into next fiscal year, and potentially even expand the number of hours that position might be available to work, in part because of the volume of documents that we're needing to scan into members' files from the correction project, but also just the volume of requests and support that the office is currently needing. So I also had mentioned that our response time in answering some members' requests will be taking additional time, in part because of volume and in part because we lost that extra help position currently. And those were the administrative updates regarding operations. There was also an item that I would like to request some board consideration on. We had brought information at the request of a member on the Serial Article 8.4, which addresses the use of separate accounts in community property divisions. I am to bring an item back to the board at the July meeting, and I have been working on that, but because of the project status right now, I would like to ask the board for an extension of when to bring that back so I can not direct additional resources away from the project at this point in time, given that our progress has been a little bit slower than we had expected. And when that initial time frame was set up, we hadn't yet heard about the Alameda decision. Of course, the Alameda decision implementation took precedent over the other part of the correction project, which is just sort of delayed that a bit. So I am looking to see if I can get a little bit of relief there as far as the due date to bring that item back to the board. There is a reminder that your Form 700 forms are due by April 1st. Please submit them to Judy. There are free trainings available on the Fair Political Practices Commission's website. If you have questions about how to complete your form and what information is or isn't required, they have a lot of information available on demand on their website. Additionally, there is the Sackers proxy voting item. We will be submitting our Sackers voting proxy form based on the direction in our policy and any board direction provided at this meeting. The business materials we hope to have available for board review at our April meeting. And there is an attached legislative update from Sackers in your packet for your reference. Did you have any questions regarding any of the items on the administrative report?
Yeah, well, Doris, were you looking for some feedback on that extension? I mean, were you thinking 6 months, or I'm not sure what you're thinking?
I would like to delay that till after we pretty much wrapped up the project, which might be probably late summer, early fall timeframe before I really have an opportunity to bring that back.
Catherine?
Yeah, my comment is just, Doris, you know best what the workload is and what needs done and what's priority. So I would certainly grant you an extension if it were my decision.
Mr. Cormer?
Yeah, that was brought to the agenda at my request, and I have absolutely no complaint or issue with you prioritizing your work in any way that you see necessary or fit. There's no way that I would ever make the argument that that topic is in any way more important than what you're working on now. So please delay it as you see fit. I don't know if the chair believes we need a deadline or a date to report back, and I trust in your guidance that when you are ready to bring it back to the board that you will. So it's completely up to the chair and all the other trustees, but I trust that when you have the information that was requested, you'll bring it back, and I don't know that a deadline's necessary. So.
Okay, why don't we just leave it at that you're tracking it and you'll be working on it as soon as you can wrap up the other project.
Thank you. I appreciate the consideration.
Okay. That takes us to, do we have any public comment on this item?
No public comment.
Chair, if I can, one more thing.
Go ahead.
I just wanted to applaud Doris on the frequently asked questions in the documents that were placed up, because I think the effort was to clearly separate in writing the Alameda from the historical benefit review project. And I think that you've effectively done that. And I hope that clarifies some issues and concerns and confusion possibly. So in my review of the documents that were posted, they are clearly separated. So thank you.
May I ask about Sacker's attendance? I did forward the meeting information to everyone. Does anyone plan on attending the conference?
I do.
Okay.
It's very different. It's a Zoom meeting. It's still going to be Zoom meeting, the conference.
Yes. Julie?
I just wanted to address that I attended the meeting on Monday for the questions regarding the historical benefit review, and listened to Doris's presentation, and she walked through how we got here from beginning to where we are now. She did an excellent job and answered the members' questions, largely relating to how to get their file, like she's commented, and how long that will take, and the burden on staff to get that while they're doing the corrections. I would encourage retirees or anyone listening to go to the Thursday meeting at 10, and when it is up on the website, to go ahead and listen and watch it. It was very valuable, and there were questions regarding calculations and so forth, and Doris did a great job answering those. So I just wanted to thank her and let everybody know that even the other board members should attend it if they're able to tomorrow at 10 o'clock, and it's worth hearing. So thank you.
Thank you, Judith.
Okay, Kathy? We're not hearing. Your audio is not coming in.
I forgot. Again, I just wanted to say that I attended the Calipers General Assembly last week or the week before. I was surprised at how professionally it was conducted. You know, they had the website that looked like the lobby of a hotel, where you could click on, go into the exhibit booths here and go into your networking room here. But I did have 6 different sessions that were really good, talking about COVID and talking about unconscious bias and cybersecurity. Anyway, it was a good conference, and I'm glad I went.
Okay, all right. Well, I guess that brings us to general board member discussion.
I guess that's where I was.
Okay. Okay, not seeing any more on that. I think, Jeff, can we adjourn and then go, or take a break and then adjourn and go to the harassment training for those who want and need to take it?
Yeah, we can take a break. I'm not sure about adjourn. Before we do take a break, I just wanted to mention, I know there may have been some issues that came up in the last couple of days about whether this training would qualify for the 1825 and that other number that I'm not recalling right now. And for those of you who may be under the impression that this does not meet those obligations, I do believe that it does. And so if you have any questions about that, I'm happy to answer them. Anyway, I just wanted to point that out before we take a break.
Okay.
And this is a 2-hour training, is that right, Jeff?
Well, I don't know that it'll last 2 hours, but
okay.
As long as it takes to get through the materials.
Okay.
I won't be returning to the meeting after the break for this session. Just like
Catherine?
I just had to take that, and it was offered by the county, and it's for, if you're a manager, you're mandated to take it. So I'm not going to be attending.
Fair enough. And just for everybody's education, that second piece of legislation that passed a couple of years ago now requires all employees to have at least some sexual harassment training. For non-supervisors and managers, it's 1 hour. Supervisors and managers, it's 2 hours.
So are board members supervisors?
No.
Well, board members are also required to have the training, and even if it wasn't legally required, I would strongly encourage it.
Jim, did you have a question or comment?
Yeah, just for clarity, Jeff, this is unique from the 1, 2, 3, 4 ethics training?
Separate, completely separate from that. Yeah, the AB 1, 2, 3, 4 is ethics, conflicts of interest. This is sexual harassment and discrimination at work.
Okay, well, we'll take a break and resume at 9:40, I guess.
for 2 out of 3.
Well, but Richard's gone.
Richard jumped. Okay.
Yeah.
So he automatically is the backup. I got it. So
No
do you have to
action
stay
item.
recording because it's an agendized item, Jeff? Is that why?
Yeah, it is a meeting technically, and
Okay.
we do have 5 trustees.
Okay. Shall we get started?
Yes.
Thank you.
So as Judy's pulling up the slides, I'll just mention that this AB 1825 training, the California legislature put it in place, I'm bad with timeframes, maybe even close to 15 years ago now. And the SB 1343 was passed a couple of years ago, I think at least in part in response to the Me Too movement. And as I mentioned earlier, the 1825 training applied to supervisors and managers and requires 2 hours of training every 2 years. This training mandates that all employees, they don't have to be supervisors or managers, must also receive training at least 1 hour every couple of years. When I was with Sonoma County, I used to do this training quite often, maybe 3 times a year, 4 times a year for many years. And I really enjoyed the training. And it's always different depending on the group that I'm presenting it for. Sometimes the crowd's a little quieter, sometimes a little more boisterous, but I've done it for road crews and the sheriff's office. And I think it's really important. You've been reading all kinds of stuff in the paper over the last several years. The governor of New York now has some issues. But kind of beyond sexual harassment, I think that employers all over the country are really taking a real serious look, I think maybe for the first time, at this concept of diversity, equity, and inclusion. And really, I think it needs to start at the top. And I'll also share that Sonoma County and the city of Santa Rosa are committing significant resources to try to really support that concept of diversity, equity, and inclusion. And it can be a little more difficult in certain fields like police and fire, and maybe the applicants are primarily white and male. And but I think it has to start at the top, and it's a culture thing. And I'm not trying to be political in any way. I'm just kind of commenting on kind of the state of the world. If you could go to the next slide, please. So what I used to do when I would do this training at the county is I'd have them spend a couple of minutes and answer these questions. I'll just go through them with you. And by the way, if any of you have questions or comments, I might not be able to see all of you on my screen now that the slides are up. So feel free to just interrupt me, and I welcome, encourage questions. So these are all true-false questions. 1, harassment occurs when a supervisor repeatedly directs a subordinate to do his or her job. And of course, that's not the kind of harassment that we're talking about. So an employee may feel like they're being harassed, but it's not because they're in some type of a protected classification or anything like that. Number 2, employees can be personally liable for harassment. That is true under California law. That's just a statute that's put on the books. And so we'll talk about under what circumstances an employee can sue their employer or an individual employee for sexual or any other kind of inappropriate illegal harassment. Number 3, an employee should be disciplined for reporting harassment if the investigation shows that the agency's policy was not violated. Well, that's false. I mean, you want to encourage employees to feel like there's somebody that they can go and talk to if they're being disciplined for some reason. If at the end of the day the investigation shows, that there was no policy violation, you don't want to discipline someone for coming forward. Number 4 and 5 are kind of the same idea. If the alleged harasser had no bad intent, it can't be harassment. If people laugh, the joke can't be harassment. intent or laughter, that doesn't absolve the person from making inappropriate comments. Next slide, please. Number 6, according to the most recent statistics by DFEH, sexual harassment claims are the most common. So let me explain who DFEH is. So under state law and under federal law, there's a bunch of statutes that protect employees from discrimination and harassment at work. And the DFEH is a state agency that employees or applicants for employment can go to. It's the Department of Fair Employment and Housing, and they enforce the state's discrimination laws. The federal equivalent, you may have heard of them, is called the EEOC, the Equal Employment Opportunity Commission. And this question's a little old. I don't even know if the, well, it says sexual harassment. The answer is false. It's retaliation claims. And I include that because if this was really for supervisors and managers, it's really important that they document things and that they don't ignore issues and that they deal with them instead of letting them continue and perhaps get worse. And so we'll spend a little bit of time talking about retaliation claims. Jokes about an individual's own ethnic or religious group are not harassment. That's like those previous questions. The answer is false. Employees who report harassment can remain anonymous. I'm curious if any of you have any thoughts about that.
It's my understanding they can, Jeff.
So I think that, I can certainly see why you would want them to be able to remain anonymous. You want to encourage people to come forward. You don't want to make them feel uncomfortable. You don't want them retaliated against. And to some extent, they can remain anonymous. But in the public sector, if an employee is disciplined, even a one-day pay loss, any type of a pay loss, entitles that person to a hearing. It's kind of a due process requirement. And fairness says that if somebody's accusing you of something, that you have kind of an opportunity to confront your witnesses. So if it's a situation that rises to the level of something pretty serious and an employee is being disciplined over it, then the person who's making the complaint does get to be known and can't remain anonymous. So you certainly want to protect it to the extent that you can, but for those reasons, you might not be able to continue to do that.
And Jeff, it's my understanding that is triggered when discipline is reached, correct? Not prior to.
That's correct. Although if you're doing so let's say that there are allegations of some type of inappropriate sexual behavior or inappropriate comments or something like that, and an investigation's done, and you're interviewing the subject employee, the person who's accused of this, depending on what the allegations are at that point in time, it may have to be revealed, or the person will figure out who the complainant is, depending on the questions that you might need to ask them.
And obviously we have a whole separate set of rules for police officer bill of rights and whatnot, but yes.
Sure, right. Number 9, employees can be disciplined even if the investigation shows that the harassment was not severe or pervasive enough to violate state or federal law. And that's true. And that's an important question because, as you'll see, the legal test, if you will, for an employee to sue their employer for sexual or some other kind of harassment is still a fairly high bar for them to be able to get money damages. But even if it doesn't rise to that level, you could have some inappropriate conducts that, whether it's verbal counseling or a letter of reprimand or even a short suspension or possibly termination, it could be appropriate. It's just a very different test to whether you need some corrective behavior as an employer versus the ability of an employee to get money damages from their employer. Number 10, a hostile work environment can exist when a supervisor has consensual relationships with subordinates. So you've probably all read articles about, all the relationships in the workplace. It's kind of interesting that we're going through the COVID. I haven't done this training since then. People are more remote. Maybe sexual harassment claims are going down. I don't know, but people meet each other at work, and a lot of employers have kind of non-fraternization policies or situations where you don't want a supervisor dating a subordinate. Obviously, if the relationship goes sideways and then the person gets dinged in their evaluation, they're going to claim, oh, I broke up with you and now you're retaliating against me. So obviously, there's a lot of risk there.
Hey, Jeff.
Yeah.
Just interject a question, because I think of the Kavanaugh hearings and ethnic remarks that were made years ago and that type of thing. Is there any statute of limitations on these, or it appears that has become more liberal in recent times?
So that's a really good question. In the Kavanaugh hearings, I could spend a half hour talking about that, and maybe I'll share a few things with you because I think it is relevant to this training. So there is a legal statute of limitations, and if an employee is trying to bring an action against an employer for money damages, they have 1 year from the date of the incident. There's something called continuing violation doctrine, so that if things have happened over time, it's the most recent incident, and so that's 1 year. If an employer were to find out about something that an employee allegedly did that's more than a year ago, I would encourage that employer to still take appropriate action, even though whoever that person may have harassed can't bring an action against that employer. But if that person is still our employee and we're on notice that they did something, let's say it's a year and a day ago, and you're on notice of it and you fail to address it, then if that person does something again, you're exposing the employer to some pretty significant risk. As far as the Kavanaugh hearings, when that was on the front pages, I kind of used that as an example because most cases like that one are he said, she said cases. And how do you prove, because most people, if they are harassing somebody, especially in a significant way, they're not going to do it when witnesses are around. So how do you assess that credibility? And the test, by the way, at least from a disciplinary standpoint or from an employee who's suing their employer for money damages, the burden of proof, if it's the employer who's taking disciplinary action, they have to show that the conduct was more likely than not. And that's 51%, right? It's called the preponderance of the evidence. If an employee is suing their employer, they have to show that it was more likely than not that they were harassed. And so if you have this he said, she said case, how do you assess credibility? And I'll be the first one to say that I have a personal bias. And my personal bias is I don't think people just make this stuff up. Now, that's not necessarily enough in and of itself, but sometimes there's some corroborating facts. And those corroborating facts can be, did the person contemporaneously tell somebody else? And in this Kavanaugh case, the lady who accused him, and I admit it was decades earlier. I mean, I think it was maybe 20, 30 years ago. I don't recall exactly. I think her name was Christine Blasey Ford. I could have gotten her name wrong, but some of the facts are like etched in my brain because it was so unusual the way she talked about what she claims happened when she talked about it with her husband, because it took her years after they were married to talk about it, and it was really unusual. I think her and her husband were remodeling their home. And I don't know if you guys remember this or read about it, but she wanted a second front door put in. And her husband's like, what are you talking about? 2 front doors. And I don't know if it was in the context of that or when they actually went to seek marriage counseling that she broke down and told them about what had happened. And she mentioned who it was. And this was some years before he was nominated to the Supreme Court. And to me, I mean, if you're trying to assess, is it more likely than not? I mean, that seems to make it pretty easy for me. But anyway, I do think that's important because when you have these investigations, you know, how is the investigator supposed to reach a conclusion about whether it's more likely than not? Next slide, please. So again, I mean, I think there's certainly some connection for MSARE and the reason that we're doing this training for the board, but you know, the documentation piece in terms of the key takeaways, it's to identify, not ignore issues and contact the experts. And you know, these are complicated issues, even for attorneys to deal with. So you want to bring in the subject matter experts who can help guide you through the process, and the importance of documentation. And you know, when I do this for supervisors and managers, you know, especially in the public sector, but in the private sector too, even before the COVID, with budget cuts and things. I mean, it's very difficult to be a supervisor or manager, and you got so many things on your plate. And the last thing you want to do is have to, you know, deal with, you know, personnel issues. They're uncomfortable, they're time consuming. But if you have kind of a problem employee who's maybe has performance issues and you don't call them out on it, and then afterwards, you know, some time goes by, and they're accused of and you want to discipline them, it could look like a retaliation claim if you don't have the documentation. And this last bullet point, 2 sets of facts, is something that I came up with to kind of, it kind of fits with the 2 prior points, and that is, once the employer's on notice that some inappropriate conduct or behavior has occurred, you know, those are the first set of facts. And assuming nobody knew about it, there isn't anything you could have done about those first set of facts. But once you're on notice of it, you know, what are you going to do then? You know, are you going to investigate it? Are you going to make sure that there's no more contact between those 2 people? You want to avoid a retaliation claim, so you want to do a thorough, fair, impartial look at the situation and figure out how to deal with it appropriately. Next slide, please. So the purpose of the training isn't to make any of you a legal expert, but to encourage you, of course, not to engage in any inappropriate behavior yourself. But if you hear about something or see something, to, you know, identify it, figure out who to talk to about it so that it can be looked at and addressed. Next slide, please. So a little bit of a history lesson. I mentioned the EEOC and the DFEH, the federal and state compliance agencies, and you know, we didn't always have discrimination laws, and Title VII is a federal law, the Civil Rights Act of 1964, and then some years later the state enacted its kind of equivalent, the Fair Employment and Housing Act. But until the 1960s, when these laws were passed, employers could do anything. They could choose to hire or not hire, or fire or whatever employees. And it didn't matter if you didn't want to hire someone because of their race or their gender or their age or any of the other list of protected classifications. And you'll see the list in California will fill the screen with protected classifications. But back in the 1960s, there were only 3 categories. It was race, age, and sex. And that law said that you as an employer can't discriminate on those grounds. And it was really controversial back in the 1960s. Employers said, you're telling me I have to hire, fill in the blank. I have to hire a woman, a black person, an old person. and the loss, and you know, it finally passed the 1960s, and you know, employers were really upset about this. You know, who is the government to tell me that I have to hire, you know, as I just mentioned, a woman, a black, or an old person, or any other, you know, race, age, or sex. And so there was nothing in the law about this term sexual harassment or hostile work environment. And then 2 decades passed. And then in the 1980s, there was a case that came all the way up to the US Supreme Court. It was a lady who worked as an employee in a bank. I don't know if she was a teller or what, but she claimed that there was inappropriate comments and conduct of a sexual nature. And she said that is, you know, I was being discriminated against on the basis of sex. And then in the 1980s, this US Supreme Court case came up with this term sexual harassment and this concept of hostile work environment. And we'll talk about what that means and what the legal test is. And then shortly after that, in the 90s, there were a lot of claims of sexual harassment, this new area of law. And of course, just recently, a few years ago, we had the whole Me Too movement, and a lot of folks were coming out saying, you know, Me Too, Me Too. And as I mentioned, that led to some other laws being put in place, including more training. And I think the civil rights issue of our generation, I mean, it kind of is really about sexual orientation and gay rights. And in fact, the US Supreme Court just ruled last year, I think it was a 6-3 decision. Remember, I mentioned that initially it was race, age, and sex. And the question before the US Supreme Court was whether sex included sexual orientation. And in California, and probably more than half the states, those states already enacted protections for employees based on their sexual orientation, but it was not clear under the federal law. And in a 6-3 decision, the US Supreme Court said, yes, sex includes sexual orientation. So sexual orientation is now protected under federal law. A couple of years ago, maybe 5 years ago now, the US Supreme Court ruled that gays can marry. And so, I mean, that's just really a huge issue. And we'll talk about in California how the law has expanded now from sexual orientation to also include gender expression, gender identity, and transitioning as a protected classification. And I just saw a little blurb in the paper today. I don't know if any of you know the actress who used to be Ellen Page. She was in a movie called Juno, which I really love that movie. Anyway, she has transitioned now, and Ellen Page is now Elliot Page. And I just saw that she was the first person on Time magazine's cover of somebody who has transitioned. So all I can say is that that is the civil rights issue of this generation, and it's going to be dealt with in a lot of interesting issues coming up, I'm sure. Next slide, please. So who's protected by these laws? Applicants and employees. And who are they protected from? So it's pretty obvious that you might think, of course, they're coworkers, but it's actually broader than that. So employers have an obligation to keep their employees protected from folks that they contract with, and also their clients. So for MCERA, I mean, it's really our members. If it was the county of Mendocino, it's anybody that county employees have interactions with, whether it's inmates in the jail or, you know, our vendors or, you know, just people out doing their job, or whoever their health and human services, whoever we're providing services to. Next slide. So discrimination is conduct taken because of somebody being in a protected classification, and even broader, if you think somebody's in a protected class, maybe you think somebody's gay because they're effeminate or whatever. Next slide. So this is the list of legally protected classifications in California. And you can see how it's grown from, race, sex, and age, sexual orientation, as I mentioned, gender identity, gender expression, and I have some slides defining those terms: marital status, medical condition. Genetic information was a recent add by the legislature, and it kind of fits in with physical and mental disability. And the reason genetic information was added, when an employee applies for a job, whether it's a public or private employer, they may undergo a pre-placement medical evaluation to see if they're physically and mentally fit for the job. And all the employer is entitled to receive is whether they have any work restrictions. But you can imagine if they found out that an applicant for employment had a certain family history of some awful medical condition, the employer probably wouldn't want to hire him. They think maybe they'll get a disability or retirement or something like that. So that was added.
Jeff?
Yeah.
I was just going to say, I really appreciate this slide. I was looking at it, just prepping a little bit, is that I recall going down to Sonoma County to my first training, and this was like 2004, 2005, and age discrimination was the headline. And there was all talk about whether or not, you should do office birthday parties anymore, what cards should look like, do you have black balloons on their 50th, all those types of things. And it's interesting in that although time will bring up another cultural issue, that we have to have an appropriate awareness of, sensitivity towards, is that you can't forget these historical things that have preceded it.
No, I agree, and I think Silicon Valley is probably an area where they're getting hit with a lot of age discrimination claims, because the high tech industry, whether it's perception or not, these are a lot of companies run by 20-somethings, and they don't want older folks around. And the age is still it's age 40, which I don't know if that's really what the age should still be. That seems a little bit on the young side to me. But yeah, no, I think that there's still a fair amount of age claims going on in certain regions of the country. Next slide, please. So gender expression and gender identity and transitioning will be the next couple of slides that we'll talk about. So gender expression, this is the term in the state law. This is the definition: a person's gender-related appearance or behavior, or the perception of such appearance or behavior, whether or not stereotypically associated with the person's sex assigned at birth. Next slide. Gender identity, how they identify themselves, each person's internal understanding of their gender or the perception of it, which may include male, female, combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. I haven't looked in a while, and I don't do much social media, but do you know how many gender choices you have on Facebook? Anybody want to guess a number? 56.
Oh, God.
And I'm assuming that you've probably been in some Zoom meetings or somewhere where you see where people have below their name the pronouns with which they want to be referred by, or in their emails, at the bottom of their emails now. You're starting to see that. Next slide. Transgender, a term that refers to a person whose identity differs from the person's sex assigned at birth. A transgender person may or may not have a gender expression different from the social expectations of their sex assigned at birth. Next slide. Transitioning is the actual biological, surgical process that some transgender people go through to begin living as the gender with which they identify. That's, at least in part, that's what Elliot Page has done, rather than the sex assigned at birth. The process may include, but is not limited to, changes in name and pronoun usage, facility usage. I mean, I see the reference there to sports teams, and I just heard a story, and I can't quite remember it, but you can imagine the issues, whether it's at the college level or somewhere else, about, are they playing on the guys' team or the women's team, and what issues that can bring. And when I was at the County of Sonoma, we definitely had some folks. I can't think of anybody at the City of Santa Rosa who has transitioned, but, and I don't know about Mendocino County, but, you work with that person to figure out, how are they comfortable? You can kind of go through a little bit of an interactive process with them. How do you want us to communicate this change to your coworkers? I don't know if the person's name is changing or what. So there's some discussions that need to happen there. Next slide. So because of these changes, there's different laws that got put into place. And so here in California in 2017, some additional protections were put in place for transgender employees. Employers are prohibited from seeking gender or sex-related information from applicants and employees. Employers must honor employees' request to be identified by a preferred gender name or pronoun. Employees have the right to use the restroom or locker room that corresponds to their gender identity or expression. I know that's been and I haven't kept up with it because Santa Rosa doesn't have a jail, but I know that's been an issue in some jails, and some cities have tried to take some proactive steps in that regard. And it hasn't really been an issue that much outside the jail setting, maybe because they're individual, single stall kind of bathrooms that kind of resolve some of that issue. Next slide. 2018, the Gender Recognition Act. This really isn't so much employment related, but it's certainly related to public agencies. Procedures related to the issuance of birth certificates, driver's licenses, and other court-issued documents to add a new gender designation of non-binary, not identified as male or female. I haven't seen any statistics on that, but that would be kind of interesting. What folks are choosing to do. It takes effect September 2018, so it's obviously been in effect for a few years. An employer's failure to acknowledge an employee's non-binary gender designation may create liability for gender identity discrimination. I'm not aware of too many lawsuits in that area, but I really haven't checked. But I haven't seen anything cross my email recently about that. Next slide. So I mentioned in the beginning that retaliation claims, at least as of a few years ago, were the most common type of claim, and so it's worth spending a few minutes talking about these kinds of claims. And it really puts into play why it's really important in this concept of two sets of facts and the need to take appropriate action once you find out about something that's happening. So the elements of retaliation case, so that's a three-part test. The first question is whether the employee is engaged in protected activity. And you see the protected activity is in quotes, and we'll talk about what that means. And the second part of the test is, did the employer take any adverse action against the employee? And adverse action is in quotes, and we'll talk about what that means. And the third part of the test is, did they take the adverse action because the person had actually engaged in some type of protected activity? Next slide. So protected activity, there's some things that are pretty obvious that, and intuitive that you might think of as protected. somebody who makes a report of discrimination or harassment or participates in an investigation, or maybe they're somehow friends with somebody who is a victim. It could also be a whistleblower. They blow the whistle on their employer for some reason, whether it's spending money inappropriately or not in compliance with certain laws. Free speech rights could trigger protected activity, right? You go speak out at a board of retirement or a board of supervisors meeting on an issue, and then you get dinged. Or maybe you have a sheriff who there's an election for sheriff, and you come down on their opponent that you're advocating that their opponent get elected. So those are all forms of protected activity. And if somebody engages in that behavior and then you go to discipline them, you could see how they'll say, oh, it's because, I reported some harassment, or because, I spoke out at a board of supervisors or a board of retirement meeting. And in fact, that may not have anything to do with it at all. But and I saw it many times over the years of my employment, that you go to a meeting with a department and it's a 10-year employee and they want to take some disciplinary action, and the person had coincidentally or not just made a complaint of discrimination. And for the 10 years they were there before, there's nothing in their file. All their performance evaluations say meet standards, but now all of a sudden it looks like they're retaliating against them just because of the timing. And maybe there's really a reason to take the discipline. And maybe there were performance issues going on before that for whatever reason were never addressed. The Janowitz case is in there because it's kind of got an interesting, fun, I suppose, fact pattern, but it talks about how the courts are still trying to figure out what protected activity is. So the Janowitz case, it's probably about 10 years ago now. She was a high-level manager for this company called L'Oreal, which is like a, clothing and cosmetics kind of company. And she kind of was the manager of a store. And one day the big boss of L'Oreal comes in and tells Janowitz, hey, I was looking at your receptionist and she's not hot enough. I want you to fire her. And Janowitz thinks to herself, well, that doesn't sound right to me. I don't like that idea. And I think if we fired her because she wasn't hot enough, it's probably illegal. So she doesn't say anything to anybody and she just ignores it. But the guy comes back some weeks later and says, hey, I thought I told you to fire that receptionist. And she still doesn't do it. So he ends up transferring her to some less desirable store, and she goes out on some kind of stress leave and files a claim of retaliation. And in employment cases, when an employee sues their employer, after the lawsuit's filed, both sides engage in some discovery and they find out about each other's case. And then what employers will try to do is they file this motion. It's called a motion for summary judgment. And basically they're asking the court to throw out the case and say, there's no questions of fact here. Based on the law, judge, you should just throw this case out and it shouldn't get to a jury. And the issue was whether Janowitz had engaged in any protected activity, because all she did was not fire this person, but she didn't tell anybody about it. And the court said that is protected activity under the facts and circumstances of this case. And it doesn't mean that, she gets a pot of money. It just means she gets to go to a jury. But I'm sure with those facts and the fact that it was about ready to head to a jury, I don't know what happened after it, but I'm pretty reasonably certain that it probably settled for some amount of money. Next slide, please. So remember, we're talking about retaliation, three-part test. That was protected activity. What is protected activity? The second part of the test is, what's adverse employment action. And obviously, if you're fired, that's the most adverse. But the courts have said it could be something really a lot less than termination. It could even be a ding in a performance evaluation, or a transfer could be considered an adverse employment action, very broadly defined. And the third part of the test is there a connection between the two? So it gets back to the issue of dealing with issues as they come up. Any questions on retaliation? Next slide, please. So, frankly, I'm not that familiar, although Judy, thank you for sending me the Mendocino County's policy and procedure on discrimination. I mean, they're basically, cities and counties and private employers for that matter have pretty similar standardized policies that law firms who advise employers, put together. And, the policy defines, the conduct that's prohibited. And there'll be some type of a process for somebody to make a complaint. And generally speaking, you'd like to have somebody at the employer who's maybe a little bit independent, at least from the department that's being complained against. So you wouldn't want the department head of the department who's being complained against to do a discrimination investigation, because it will seem, at least the appearance of bias. So you want to have somebody within your organization who's seen as an independent, more neutral person, usually somebody out of the HR department who can look at the issue, and maybe depending on the severity or significance, you'd hire an outside attorney to do the investigation. But if you even need an investigation, and that's what the procedure is. It defines a process when there is a complaint. The fact sheet is something that's I should have deleted from this slide. It was unique to Sonoma County, but probably Mendocino County has something similar where, you could go 20 years and not ever have this issue come up in your employment career, and then all of a sudden there are allegations, and it's just designed to help somebody kind of understand, what's an alleged perpetrator. That's the person who's the accused, and kind of in a very understandable way. I think it's actually a good idea for employers to have it so folks can kind of understand what's going on and what the process is. And there's a fair amount of integrity to the process. I mean, you want it to be a fair, impartial investigation, and it can put a department head in an awkward position if there are allegations of inappropriate conduct, right? Because then that department head has to send a letter out to the person who's accused saying, there's allegations that you've engaged in inappropriate behavior. There's going to be an investigation. You're directed to be truthful. Failure to be truthful could result in discipline up to and including termination. Most employers tape record the interviews. So it's a very, it can be a very awkward, uncomfortable process. But, ultimately, that's what employers need to do. And it does, hopefully protect and is designed to find out what happened and to take appropriate action. Next slide. So there's two types of harassment: quid pro quo and hostile work environment. Quid pro quo is a Latin phrase. It just means this for that. I mean, the common thing is, if you want to get a job here, sleep with me, kind of a thing. And frankly, over all the years, I haven't seen that come up. And I don't know if it's just because it's remained quiet, hush hush, or because governmental agencies are so bureaucratic that one person doesn't have that kind of power. It's a little more formalized hiring process. But, maybe that's a little bit naive, thinking of, extra help folks who become permanent employees. But for whatever reason, I haven't seen many of those cases. Hostile work environment we'll talk about, and there'll be some slides, and that's a very much more common issue. Next slide. Next slide. So hostile work environment, I talked to you about that case in the 1980s that went up to the US Supreme Court. And basically the test is still the same, although I think that, and I'll give a case example in a minute, but the legal test really hasn't changed, but I think the sensitivity and the recognition of what's severe or pervasive has changed. And I'll explain what I mean in a minute. So the legal test for an employee who wants to bring a lawsuit against their employer to try to get money damages, we're not talking about discipline here, is physical, verbal, or visual behavior of a sexual nature. And the sexual nature part is really sex harassment, but it could be physical, verbal, or visual behavior of, and then fill in the blank of any one of those protected classifications. So it could be about somebody's race, it could be about their sexual orientation, it could be about their age, but it has to be on that list or it's not actionable. It has to, the behavior has to be objectively and subjectively offensive. And what that means is, objective means a reasonable person. A reasonable person would have had to find it offensive. So if somebody's just super hypersensitive to a comment, then they won't be able to get money damages. That's what the law says. It also has to be subjectively offensive, meaning that that person themselves found it offensive. And then last, yeah?
Just one question, because it seems to be an area where people are called out a lot these days, is on the visual behavior. It used to be, you have something sitting on your desk or a picture in your cubicle or whatever. With social media these days, does that extend to posts? You like somebody else's post? And just as a hypothetical, I'm thinking, I've seen in the news the last couple of days where, San Jose selected a new police chief, and there was concern expressed by at least one person who was transgender about whether or not there were some issues there about his feelings towards transgender individuals. Merely like liking or commenting congratulations on an appointment on social media, does that start to fall within this realm?
Wow, that's such a great question, and it brings up so many issues. And the first thing I should probably mention is on a somewhat related issue, and this really relates to all of you as trustees, is that there was a change recognizing the significance of social media, and the legislature made a Brown Act change. In fact, I probably should have sent an email to the trustees about it. So let's say, Jim, you've got a Facebook post and you comment on something MSARE related, maybe something about the project, whether it's something negative or positive, and you make a comment on it on your Facebook post that's open to all, and then Quincy likes your comment. And that's just two of you. That's not a quorum. That's actually now prohibited under the Brown Act.
Mm-hmm.
So it used to be you had to have a quorum, a majority, but when it's social media, just two members of that board. So if one posts something that's a work-related, something that could come before that body, you can't even have one other trustee like it. That's a meeting and would violate the Brown Act. I'm sure, because Brown Act violations can be a misdemeanor, I don't think either of you would be prosecuted. It's a new law and it's a pretty subtle thing, but it's embarrassing and it's something that you should just learn to know not to do. Your question was very different, and it raises all kinds of issues, including the right of free speech. And is it work-related? And so free speech, I could spend an hour talking about that, and I've had some very interesting cases. In fact, I will share one, and I bet Quincy is going to get will be interested to hear it.
Sorry,
so the free speech area in public sector is really very interesting, and and it can come up quite frequently. So the first part of the test for free speech in the employment sector, in the public employment sector, is the person speaking as a member of as a private individual, or as an employee? If they're speaking out about an issue that the public would be interested in, and it's not just a work-related thing, then the protection may apply. The second part of the test is how it's connected to the workplace. And let me just use an actual example. So years ago, there was a correctional officer for Sonoma County who wrote a letter to the editor of the Bohemian. I don't know if you're familiar with it up in Mendocino County, but it's just kind of it's a left-leaning free newspaper that I'll just leave it at that. And they were writing a lot of stories that were very negative about the sheriff and the sheriff's department because they were getting hit with a lot of sexual harassment lawsuits. This is really going back quite a number of years now. And this correctional officer wrote a letter to the editor sticking up for the sheriff and the sheriff's department, but arguably he went a little too far when he said in his letter to the editor, identifying himself as a correctional officer, he said, you, the writer of the story, and the editor, who were a married couple, probably met at the Haight-Ashbury clinic when they came in for a VD test. And so the sheriff believed that that was conduct unbecoming an officer and gave him a letter of reprimand. And he fought that all the way up to the Court of Appeal. And the Court of Appeal agreed with him, saying that that was his right of free speech. And to this day, I think that's a wrong decision. And while he was speaking out on a matter of public concern, he identified himself as a correctional officer, and officers are held to a higher standard. And then the third part of the test is you kind of have a balancing between the person's right to free speech with what detriment could be caused or discredit to the department by making a comment like that. So anyway, that was a very long answer, and I don't even know if I answered your question.
Thanks. It gives me an idea, just as to understanding that there are some landmines for us in the social media world. Yeah, definitely. That's definitely the case. Next slide, please. I think that will kind of talk about severe and pervasive. So severe and pervasive has to do with the frequency of the conduct and the severity of the conduct. The legal test is whether it unreasonably interferes with somebody's work. The physically threatening or humiliating, I hope it doesn't come to MSERA, but that always reminded me, that bullet point always reminded me to talk about threat assessment teams, which I sat on at the county and I sit on for at Santa Rosa. It comes up in the workplace in so many ways, whether it's not just two coworkers who don't get along, but a member of the public who is threatening. Or it could also be domestic violence issues that spill into the workplace. We used to have our sheriff's office flag for us anytime there was a restraining order involving a county employee, because we do have an obligation to keep a legal obligation to keep our employees safe. But fortunately, I haven't seen that issue come up at MSERA, but it is a significant issue, obviously, workplace safety and security. The Moakler case is probably close to 15 years ago, and I was always a little hesitant to talk about it because I felt that the decision that the court made really sends the wrong message, and I've never seen another court cite to it, and I'm quite confident that in today's age of at least what people think of as more progressive thinking, that you'd get a different result. But I'll briefly tell you the facts as I recall them. So Moakler worked for Orange County, and she was one level below the department head.
And the person that she was accusing of inappropriate behavior was a member of the Board of Supervisors in Orange County. I'm kind of blanking on his name now, but anyway, this case went to a jury trial, and the testimony from Moakler and maybe some others were essentially that this member of the Board of Supervisors made comments, was flirtatious with her, put his arm around her and asked where she lived, and kind of looked her up and down in a suggestive way. He told her she had nice legs. But then the piece that, was a little over the top, I thought, was that he intentionally rubbed her breast with his hand. And that was the facts before the jury. And the jury looked at they look at jury instructions, and there was kind of this test that I've kind of put before you, and they concluded that it was severe and pervasive. And the attorneys for Orange County asked the judge, there's a procedure called a motion notwithstanding the verdict. And they said, Judge, based on that evidence, it was wrong for the jury to find that severe or pervasive. And the California Court of Appeal agreed and overturned the jury's decision. And so I really believe that you'd get a different result today. I'm kind of reminded of the case, and I can't quite remember the facts. It was a criminal prosecution of a guy who went to Stanford and basically raped an unconscious co-ed behind a dumpster, and then a judge kind of gave him a light sentence, and now that judge isn't even a judge anymore. But I mean, he got recalled or whatever kind of process happened there. Anyway, I think you'd get a very different result now. Clearly inappropriate behavior, and we talked about how the difference of a legal standard versus a disciplinary standard. I'm quite confident that any employer would terminate an employee for that kind of behavior. Now, of course, this person was on the Board of Supervisors, so they can't be terminated. Anyway, somebody Googled that person's name during one of the trainings I was doing and found out that he was successfully prosecuted on an unrelated matter for some type of battery or assault. So anyway, we'll move on from that. Next slide, please. So that was the test for an employee who wants to sue their employer to get money damages. The hostile work environment test for discipline, it really just goes to how severe was the behavior. Is it an occasional or one offhand comment that might merit some kind of verbal counseling, or was it inappropriate touching like in the Moakler case, which would result probably in termination? And so it just really varies depending on the facts. And it doesn't matter if the conduct between two people is welcome. If a third person overhears it or a manager and thinks, well, that just doesn't belong in the workplace, then it needs to be addressed. Next slide. So visual harassment, posters, cartoons, bulletins, calendars, staring, leering, emails, and the internet. So I'll spend a few minutes just talking about emails and the internet. And obviously I've seen cases where folks go to websites that they shouldn't be, or send emails or forward emails. So, you really need to be thoughtful about that. I'm assuming Mendocino County and kind of and MCERA has adopted a similar, or because the county has the policy, when public employers want to do a search of somebody's work computer, because it's still a government employee, it's the government doing a search, even though it's in the employment context. And so the courts have said that employees have Fourth Amendment kind of rights from search and seizure. And so an employer is legal, a public sector employer is legally justified to do a search of an employee's computer if they have a reasonable suspicion that they've engaged in some type of inappropriate conduct on it. But you don't even have to have reasonable suspicion if you have a policy, and we probably should check. I'm assuming Mendocino County has a policy, maybe some of you know, that says, and you've signed it, I know it's Sonoma County, we have it, and it's like in 3 or 4 different places in bold. You have no expectation of privacy in the county's computer, and we can search it. And then you don't even have to have a reasonable suspicion, and it can be searched at any time. And those searches are done, they're not done randomly to see what people are doing, at least as far as I know. But if somebody says, hey, I got a complaint that either, and it might not even be sexually related, right, that somebody's just surfing the internet when they should be working, but certainly if they're at inappropriate websites, the county's policy recognized that you could use the county computer for personal purposes. I mean, it's just reasonable to think, you might check a score on ESPN or make a reservation, but if you're spending half your day doing things you're not supposed to, that's a different story. The other thing I want to mention about emails has nothing to do with sexual harassment, but to just kind of take this opportunity to remind you all about Public Records Act requests and to be mindful of the emails that you create. Do you need to create it in the first place? If you do, be thoughtful about what you say. Next slide. Physical harassment, massage, hugs, and touching. So this is certainly a touchy subject. Everybody has a different comfort level. And the best advice is, hands off kind of a thing. But, certain work groups, I mean, I was doing one for a Health and Human Services department some years ago, and I'm sitting there waiting for them to come in, and pretty much everybody hugged each other as they came in the room, and they were a tight-knit group, and I think they dealt with some difficult issues, and it was just a real kind of camaraderie. And so, but everybody does have a different comfort level, so I'll just leave it at that. Next slide. Verbal harassment, sexual comments, ethnic jokes, mocking accent, teasing, posters, calendars. So I don't know if I talked about this the last time I did it for this group, but I think we got some new folks. When I see the mocking accent, I still think about this comedian who is Indian American, and he talked about what his life was like in middle school because of this character on The Simpsons. And I love The Simpsons, and I really thought this character was funny. His name is Apu. He runs the Quickie Mart, a convenience store. And he is an Indian American guy who happened to be voiced by a white guy. But at least back then, and even still to this day, there just aren't many of those kind of characters on TV. So this is, the whole world to this guy who is a middle school guy who is now a comedian and talks about how horrible his middle school years were because people made fun of him because of this character on The Simpsons. And he turns it around in kind of a self-deprecating way, but he was genuinely negatively impacted by this teasing. And what one person thinks is funny is really horribly uncomfortable to somebody else. So, next slide. Gray or borderline areas, consensual relationships between supervisors and subordinates. We kind of talked about that. Consensual is in quotes because, if you're a supervisor of somebody and you ask them out on a date, they may feel like they can't say no. Solicitation of dates, invitations to lunch, drinks, or dinner. There's nothing illegal or improper about asking somebody out on a date. It's all about, reasonableness. I mean, if you ask somebody out 32 times and 31 times before that they said no, you probably need to understand the situation a little better. Same thing with, references to appearance or dress. And touching, we talked about that. Next slide. So in a perfect world, if something happens between two people in the workplace, it would be great if the person felt comfortable to say, hey, it bothers me when you say those kind of things, but everybody has a different comfort level. And I do think most people, if they were told to knock it off or that it offended them, I think most people would say, oh my gosh, I didn't mean to offend you, and would stop. But if you're not comfortable or it doesn't stop, then that you need to know who you can go talk to about it. And we kind of talked about this a little bit already. Whether you can go up within your department or maybe you're not comfortable with that. And that reference to the EEO manager is somebody maybe out of the HR department who could be seen as neutral. But there's no obligation that you stay within your employer, although the employer would probably prefer it to see if they could deal with it themselves before you go to the DFEH or the EEOC to make a real more formal complaint. And then, of course, the law prohibits retaliation against somebody who makes a complaint. Next slide, please. So I don't want to bog you down too much in these next series of slides. I think the really important takeaway from the next couple of minutes is situations need to be addressed, not ignored. And again, it comes back to that concept of two sets of facts. The first set of facts, things already happened and there's nothing you can do about them. But the second part is really critical. Once you're on notice, do you really make a good effort to fix the problem, so to speak? And so the legal tests are different, whether it's a supervisor harassing a subordinate or it's two co-workers. Because if it's a supervisor harassing a subordinate, the courts say that employers are strictly or automatically liable, whether they knew about it or didn't even know about it. So it's really a big deal. Next slide. So the first question is whether the person is even a supervisor, and it's broader than just somebody who does their evaluation. But if they direct their work, then they could be considered a supervisor. We actually had that issue come up in Sonoma County, and I think it ended up in a published court decision. We had a DA investigator sue a deputy DA and the county for sexual harassment, and they worked on white-collar crimes, and so it was just the two of them. So he wasn't her technical supervisor. He didn't write her evaluations, but he certainly gave a lot of input to it because the supervisor had to rely on him. And frankly, I think the courts reached the right conclusion in saying this guy was technically her supervisor. And so if that's the case, it's a strict liability test. Next slide. So the courts have said that if you have supervisor subordinate harassment, whether it's sexual harassment or the harassment on any of the other kinds of terms in that protected classification list, the employer is going to be automatically liable, but the employer can reduce or perhaps even eliminate damages if they can show three things. Next slide. So the first is that there was no adverse employment action taken against the person who made the complaint. So the first thing you're going to do when there's a complaint is figure out, what am I going to do with the folks while I do the investigation? And what if the employer says, I think what works best for our small group is if I move the person who made the complaint over here while we investigate. And sometimes these investigations can take a month. Well, if the person who makes the complaint gets moved over here, they're going to say, why are you moving me? I made the complaint and you're moving me. And that could be considered an adverse employment action. And so you've already blown your defense. So you want to be mindful of that. The second part of this test for the defense is that has two prongs, and this is easy to satisfy. The employer takes reasonable care to prevent and correct bad behavior. And you do this by having a policy in place and provide training. And next slide. And that you refer the matter out to be investigated. And if the allegations are sustained, meaning you think it's more likely than not that it happened, that you take appropriate and timely action to correct it. The third part of the test, the courts put some responsibility on the shoulders of the person making the complaint. And if they, and this gets to the question Jim raised earlier about kind of a statute of limitations piece. If the employee unreasonably failed to timely inform the department, then the department may be able, or the employer may be able to say, hey, there's no way we knew about it or should have known about it. But still, when you're dealing with a supervisor, it does put the employer in a little bit more of an awkward spot. But if you can meet this defense, then you may really be able to significantly reduce or eliminate damages. Next slide, please. So coworkers. So the employer is not going to be liable unless they knew or should have known about the behavior. So if it's the first set of facts, like I'm saying, and there's no way we reasonably could have known about it, that, you know, the supervisor wasn't looking the other way kind of thing, then there's no liability. How do you know? You know, it's training, be proactive. You really want to encourage a culture where people feel like if they come forward with something, it's going to be respected. Next slide. Reports of harassment to supervisors, you know, could be by somebody other than the victim. From time to time, I've seen this come up. Hey, I want to let you know this is going on, but I don't want you to do anything about it. The law is very clear that once you're on notice, you have to do something. So, you know, we want to try to respect employees' privacy, and that gets back to whether you have to reveal their identity, and, you know, depending on how severe the situation is, you might have to, but you want to be mindful of it. Next slide. Straightforward. Responsibilities of supervisors: advise management, cooperate, prevent further harassment, don't retaliate. Next slide. So you don't want to ratchet everything up into a full-blown investigation where, you know, there's a formal interview, whether it's tape recorded or not, but maybe sometimes, you know, whether it's somebody in HR, you know, you can have some conversations and maybe there's some discussion, and you want it all memorialized so that you can show you took whatever action you did, and that the person felt comfortable with the resolution. And maybe it can be dealt with on a fairly low level. But if not, next slide. Then you have a more formal situation where somebody's going to need to conduct an investigation, whether it's somebody internally like an HR department or an outside attorney. And their role as an investigator is to be a neutral fact finder and to just gather the information. And then, you know, different employers do it differently, whether you want them to have findings and a conclusion, like, you know, I think it's more likely than not that it happened and the county's policy was violated, and possibly a recommendation, which, you know, may just say, you know, appropriate disciplinary action should be taken. Next slide. By the way, one thing I kind of forgot to mention, but when I talked about the confirmation hearings for Justice Kavanaugh, you know, there are credibility determinations the investigator has to make. And so if it is somebody out of HR or an attorney, I mean, you know, they should be an experienced investigator and, you know, have had training in assessing credibility. And, you know, maybe you ask them questions and they look you right in the eye, and then you ask them a tough question and they reach for their water bottle, or, you know, they don't look you in the eye, or whatever it might be, or whether there's, you know, whether they contemporaneously told somebody else at the same time about what had happened, because it will be a he said, she said case. Documentation supervisors can gather. I mean, it's the who, what, where, why, and when. That bullet point about contextual information, sometimes there's a backstory or some other issues going on, might be helpful to know about. Next slide, please. Personal liability. So under state law, both supervisors and non-supervisors, any employee who harasses or retaliates can be personally liable to pay damages under that test we talked about earlier. And here you can substitute Board of Retirement, I suppose, although technically it's always such an interesting relationship between MSERA and the County of Mendocino, because Judy and all the other staff are employees of the county. Technically, only Doris is the only employee of the Retirement Association. Anyway, if as it states there, if the Board of Supervisors finds your conduct to be outside the course and scope of employment, the board may decide to not defend or indemnify you. So let me explain this. So if an individual employee sues a coworker and or maybe the county or the retirement association, the board meets in closed session to talk about it, and they'll, after the investigation was done, they'll find out what they believe the facts are. And if those facts are such that they believe that this person did this behavior and they find it to be pretty extreme behavior, then they could say that's considered outside the course and scope of employment, and the board can decide to not provide that employee with an attorney or not indemnify them if at the end of the day a jury comes back with a verdict against them. And I haven't seen this situation come up at the city. I haven't been there that long, but I was with the county for many years. And it's I think there were maybe 2 cases in all those years where the board said, we're not going to defend or indemnify them. And I'm not going to get into the specifics of those cases, but those were really egregious facts. And so that, that's a prerogative that a board has. And that course and scope of employment, that's a legal term, and the cases have talked about it, but that's basically how it works. Next slide. Prevention, a much better topic. Report complaints as soon as possible, take them seriously, follow the process, be a good role model. Next slide. So what if the actions aren't tied to a protected basis? That list of classifications earlier, maybe there's some kind of mediation or employee assistance program can help if it's just 2 folks who don't get along. Next slide. Bullying. So this was added to the legislation and requires employers to include a discussion of bullying behavior in the training. The bullying in and of itself isn't a protected classification or a form for somebody to file a lawsuit, but there's probably different ways that an employee could form that into some kind of, whether it's a workers' comp claim or some other kind of claim, but it's not a protected classification in and of itself, but the legislature said we need some training on this. And so they defined abusive conduct as conduct by an employee at work with malice, that means intentional behavior, that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interest. And they gave examples: derogatory remarks, insults, verbal or physical conduct that's threatening, intimidating, or humiliating. And I've certainly seen situations over the years where some supervisors, they are just over the top, whether they're screamers or mean or rude. And does that rise to the level of bullying? Maybe. But nobody should have to put up with that kind of stuff at work. And so I always encourage folks, if you've got a supervisor like that or a coworker, tell somebody about it and let it get addressed. Next slide. So the key takeaways: don't ignore the issues. This concept of 2 sets of facts, we've talked about that. Next slide. So I'll just go through with you the post-test here. The first question: what's the investigator's role, whether it's some person in HR or the attorney? And as I just mentioned, neutral fact finder. And they do have to make credibility determinations if it's a he said, she said case. If you get a complaint of discrimination, you need to tell somebody about it. And it's that whole second set of facts idea, do the right thing. If the alleged conduct would not violate the law, you need not be concerned about it. That's false. We talked about the different tests between trying to get money damages, the legal test versus the disciplinary test. Next slide. rights and responsibilities are explained in the county's policy on, non-discrimination. And yes, employee coworkers who harass somebody can be personally liable. That's true. Next slide. If the conduct occurs away from the workplace, it can't be harassment. We didn't really talk about that. That's false. It kind of depends, need maybe a little bit more information. You could be at a conference, you could be at a training, maybe you're at an after work event where folks go out for happy hour or whatever. And, it's a question about having a nexus with the workplace. And that kind of gets to Jim's question about the sheriff or wherever it was who posted something on Facebook. Is that really kind of off duty, or is that still connected to work somehow? And that's what the question would be. Number 7, if a manager should have known that one of her staff was sexually harassing a coworker, the county could be liable. That's true. It's the knew or should have known test. Next slide. During a break at a board meeting, the administrator, staff, and a few board members are chatting. One person makes an off-color joke. What, if anything, should the administrator do? I won't put any of you on the spot to answer that, but it would be great if the person felt like they could be comfortable enough to say, it really bothers me when you say something like that. But, it takes a little bit of courage, first of all, and you have to feel like you won't get retaliated against or made to look, like, oh, you just can't take it, huh? It kind of reminds me of the training I did for these for this public works road crew. And, I think, it started off, that they would kind of maybe make fun of it a little bit. But I think by the end, I kind of feel like they kind of got it. And I thought it was really cool, frankly, that, they really kind of were thinking about, how is this making somebody else feel? And anyway, it's just kind of important, I think. Next one. This is a long one. I always like this hypothetical because it talks about growing up in a bad neighborhood, and I always like to talk about how I grew up in Detroit. Actually, a half mile from Detroit. But if you ever saw Eminem's movie 8 Mile, I grew up at 8.5 Mile, and it was kind of a tough neighborhood. And where I live here in Santa Rosa, the neighborhood feeds into a really kind of a safe, nice, economically privileged to some extent elementary school, but the middle school feeder is in kind of the downtown part of Santa Rosa, and some people felt like they didn't want to send their kids to an urban school. And I'm just thinking, not that we don't have crime in Santa Rosa, but it's not like where I grew up. And but everybody has a different comfort level, and that's what this question number 9 is about. The store is located in a bad neighborhood, and they're interviewing for a manager, and they're worried that something could happen to her. She might get mugged, or the customers might use rough language. So if they didn't hire her, is that sex discrimination? Maybe. And the point is, you should just let somebody know about the job and let them make the decision for themselves. So that's what that question is trying to get at. Number 10, next slide is, maybe some of you are cynical, but the number one reason most people file complaints is A, money, B, revenge, C, cover up their poor work performance. I really think most people who file complaints really just want the behavior to stop. I don't think they're trying to win the lottery, although of course, there's always some people who are, but I think they're kind of a minority. Anyway, that's it. It's kind of weird to do this on Zoom, but anyway, we got through it. Any questions or comments or anything? I can't even see half of you.
Yeah, this is Kathy. I have a comment. I just did the Calipers General Assembly thing, and they had a session, and it was on unconscious bias, but it was just so interesting. It ties into so many things that you're saying here, but it went from historical stuff. Like in the 1960s, I think they said TWA made you quit being a stewardess at age 26. After that, you were too old to be a stewardess, which was interesting. But then it was talking about blind applications, which is what everybody's apparently moving toward now, taking names and identifying information off of your applications, even your address and stuff, because where you live may tell them something about it. So they're looking at applications just based upon the skills and abilities and work experience and all of that. And one of the examples they also used was an orchestra, professional orchestra, hiring professional musicians, and that they started putting up a screen on stage so you couldn't tell what they looked like. And then the people hiring were just listening to the music. But then they had to make everybody take their shoes off after that, because you could tell by who was walking across the stage whether it was a male or a female. So it's just, things are changing very rapidly out there, and how people are going to, what they're going to do to try not to be discriminatory is something that I'm glad I'm retired. That's all.
I was going to say something or add something kind of similar, is with all of the unconscious bias now, and especially coming to like racial issues, is there's a lot of talk about people working on themselves and learning and so forth. And partly comment because I know, Jeff, you talked about know or should have known, and a lot of these things nobody could have possibly known. But it would seem like if there hasn't already been, very shortly, we may get a legal challenge as to whether or not discrimination occurred on something where there was, unconscious bias or kind of institutional bias.
Yeah, I think you're right. Cutting edge.
I think I'm really getting my eyes opened on a lot of things, and the racism is one of them, because I didn't grow up in Detroit, but just listening to people being accused of racism because when they were in college many years ago, they went to a Southern plantation themed ball, and the picture surfaces, 15 years later, the picture surfaces and they're being accused of being racist. Whereas does that fit into the known or should have known? Should I have known that dressing up as a plantation lady, I don't know. It's just hard for me. I'm just trying to wrap my mind around it.
I was wondering about religious bias, and that's not on the list, but does that fall under another category? Or does that happen?
Well, and maybe this is a little different, just like there's a disability accommodation, employers have to accommodate somebody with a disability. Employers do have to accommodate employees who have a religious component to their situation. Maybe they can't work on a Sunday or other issues. And as long as it's a genuinely held religious belief, employers are required to accommodate that. And you go through the same type of analysis. So I think if you're talking about maybe national origin or race, I mean, those are the protected classifications. So maybe it comes at it from that angle.
Mm-hmm. Yes.
Yes.
Can I tell you a story about how different things used to be?
Of course.
When I was a UCLA co-ed after my sophomore year, I decided I didn't want to go to school anymore. I wanted to go make money so I could buy a nice car and start my adult life. So I went to an aerospace firm, and the head of HR, I applied for an executive secretary position, gave me a typing test. I had passed everything up until the typing test. And I typed fast, 70 words a minute, with 29 errors. So there's no way you were going to get hired when you really couldn't type well at all. So this man, head of HR for a large aerospace firm, gave me the test and told me to go home and practice until I could type at least 60 words a minute with no more than 2 errors. And I went home to my parents' house at that point, and I did nothing but do the test over and over and over. I came back in, and I typed 64 words a minute with 1 error, and I got the job. Problem was, I still couldn't type, and I'd been hired as an executive secretary. I think because at that point I was cute with a long blonde ponytail, and he thought I don't know what he thought. I kept having to take anything that was typing to a real executive secretary to clean up the mess that I made. Because, you know, when you made an error back then, you had to use whiteout or whatever. He had obviously hired me for the wrong reasons, and I just couldn't imagine. To cut it short, after spending 2 months at this place and being a terrible failure in the typing department, I was more than happy to go back to UCLA and be a co-ed and finish my next 2 years and even graduate school. But I just wonder how much both he and I would have been on the wrong side of any kind of good harassment or discrimination policy. Or he would stop by occasionally to see me, but he did not do anything that was untoward, other than to give me a job that I really, really didn't know how to do. He thought I would be, a decoration for the company.
Yep. Well, yeah, I mean, there's been all kinds of stories about inappropriate kinds of things on a much more severe basis. So at least it was just the job offer, I guess. Any other questions or comments, anybody? All right. Have a good day.
Thank you, Jeff. Made it pretty painless.
Good.
All right, good.
All right, so meeting adjourned.
All right. Yeah. Thanks. See everybody.
Thank you. Everybody, I'll follow up with certificate.